Okay, next up, we have Jim Beck, who is going to present on eminent domain mineral property valuations when self-proclaimed latitude falls somewhere south of competence and ethical obligations. It sounds interesting. And James M. Beck, PE, and qualified person, is a registered professional mining engineer and qualified person with over 40 years of experience in the industry, the last 10 years of which have been largely focused on participation in mineral property appraisals. Mr. Beck holds a Bachelor of Science degree in mining engineering from the Michigan Technological University in Houghton, Michigan. He has worked for Arco Coal Company, Anaconda Copper Company, Arco Australia Ltd., and international consulting engineering firms. For the past 25 years, he has been the founding principal and mine evaluation engineer of J.M. Beck & Associates Mining Consultants, located in Denver, Colorado. Please welcome Jim.
Thank you. I'd like to say that this afternoon's session has been very interesting and provides an excellent lead-in to this discussion. In fact, this gentleman's last question, I think, pretty well summed up what I'm going to talk to you about today. Most of these sessions have focused on how to do the appraisal process, and I'm here to talk a little bit more about how not to do it, perhaps. And I would have to say that this is going to be focused on the mining appraisal business. I apologize to the petroleum, oil, and gas folks, but I suspect many of these concepts and many of the same problems will be encountered in that area as well. It's even going to be very much more narrowly focused toward eminent domain as opposed to pure property appraisal. I'd like to start out with just a summary of what we're going to talk about here in this discussion. I used the word latitude in the title of my paper. And if you look up the definition of latitude, it's under Merriam-Webster, is listed as freedom of action or choice. You notice there's no bounds placed on that. It looks like it's wide open. And that's the concept that I really want to address here in this discussion. And I'm going to tackle it from the context of mineral appraisal competency, how this competency affects the highest and best use determination, and industry standards and guidelines, how they come into play with the process itself, and then step back a little bit and look at some of the deceptive appraisal practices that we've witnessed in the last 10 or 12 years on a number of eminent domain projects and the harm that can be caused by these types of practices. And obviously, hopefully everyone will glean from this that there are ethical implications. And as been previously discussed, there are some enforcement capabilities out there to address these issues. So with that, I'd like to talk about the fact that eminent domain appraisal requires specific competence in both eminent domain appraisal theory, as well as all stages of the full mine life cycle. The appraisal competency is generally addressed under USPAP, under the Competency Rule, where you must be competent to perform, or if not competent to perform the full scope of the appraisal assignment, acquire the necessary competency by contracting with other individuals to participate in the appraisal process, or decline or withdraw from the assignment. In all cases, full disclosure is going to be required when you're putting your report together if you do move forward with the appraisal process. Probably good to disclose to your client why you can't move forward as well. Mining and minerals competency is a little bit more broader scoped, and it requires a full understanding of exploration and the concepts of economic geology. It's going to require the ability to conduct data analysis and resource estimating. Mine planning, design, and reserves quantification is a very important part of the minerals appraisal when you're looking at a mining property. And to go one step further, you also have to have the knowledge of how this mineral is going to be processed and what extractive metallurgical techniques are going to be utilized. So ultimately, you hopefully have also the background in mine project analysis and economic evaluation, running the full gamut of permitting, development, operation, closure, and maybe in some cases even post-closure will enter into the evaluation itself. All of these are gained only through education and experience, and I think the previous talk touched on that quite well. The deficient mineral appraisals that I've been running into in the last 10 or 12 years while working within this arena have generally been found to be the result of lack of competency in appraisal theory. Now that's bad. We also have lack of competency in the mine development process. That's really bad. What's even worse is when someone undertakes the assignment lacking both of those areas of competence, and it's completely unforgivable when they move forward knowing so. All of this generally leads to a determination that there's a failure to properly determine the highest and best use of that property. Now, I'm talking primarily of undeveloped mineral properties. They may have had historic operations on them, but for all intents and purposes, these properties are dormant as of the time of the effective date of the appraisal. So I found a number of interesting quotes that were contained in the IIMA newsletter back in May of 2017, which would also be another good educational source that I think I would refer people to. Go through some of these newsletters and you'll find a number of these procedures and policies outlined in very good detail and contextual references. The ones that I picked up on highest and best use, and these are direct quotes from those publications, is that the determination of highest and best use is a fundamental aspect of appraisal, and it's frequently misunderstood and often neglected. But more importantly, the highest and most profitable use for which the property is adaptable or needed, or likely to be needed in the reasonably foreseeable future. Now, why do they say in the reasonably foreseeable future? They also have a quote contained in to address that, and that's to make sure that the appraiser is not using a process that involves mere speculation and conjecture to become a guide for the ascertainment of value. The elements of highest and best use have been on this slide screen here several times this afternoon. Again, they are sequentially in order: physically possible, legally permissible, financially feasible as of the effective date, and maximization of the potential. I've highlighted financially feasible there because if you can't get past number 3, financially feasible, you can't get to number 4 and demonstrate that you've maximized the potential. Focusing on undeveloped mineral properties, I always like to say that there's a reason why a mineral property that is currently an undeveloped mineral property as of the effective date is an undeveloped property. And that's because typically it has not been demonstrated to be economically feasible to develop that property at that point in time or prior to that point in time. When we talk about financial feasibility in a little bit more depth, again, IIMA has stated that an appraiser cannot consider stages of development of a property that are conjectural and speculative in nature, and more importantly, have no basis in fact. They go further and state that a fresh mineral discovery cannot be determined to have a highest and best use of mineral production because that would constitute mere speculation. Now, the last gentleman here that posed the last question, I think, was starting to touch into the area that I'd like to talk about a little bit here, and that is that any appraiser or any valuer can take any hypothetical mine project and demonstrate it to be financially feasible if you make the right assumptions. Generally, those favorable assumptions that are put into play that are unsupportable end up with a false determination. These false determinations of financial feasibility do not equate to a highest and best use definition of maximizing potential. The building blocks of the financially feasible deception process. Some years back, approximately 4 or 5 years ago, I think I saw a study that was conducted by Rio Tinto, a worldwide mining concern. And then in the past year, I found substantiating data from another organization that documented the fact that 99% of all exploration projects do not become mines. In my 10 or 12 years of experience in the eminent domain appraisal of mineral properties, I've found out that basically 100% of these properties have been determined through speculation and conjecture that every one of them will become a mine. It's somewhat mind-boggling to me, having worked on numerous properties for mining companies, the number of properties that did not advance to mine stage, development stage, but yet when we get out into an eminent domain situation, we have a small property that hasn't ever even been looked at for mineral potential, but yet we find out there is a quote-unquote economic mineral occurrence on that property. Virtually every one of them is proposed to be a mine by the opposing appraisal team. These speculative mines are then modeled using an oftentimes impressive but unsupportable capitalized net operating income discounted cash flow model. This generally results in an unsupportable net present value, and that's taken one step further. That net present value is then asserted to be the value of the mine or the mineral in place, and oftentimes these appraisers are typically using those two concepts of the mine or the mine project versus the mineral in place as equally equivalent appraisal process subjects, and that is an incorrect approach. In order to determine financially feasible component of the highest and best use, the appraiser has to know the difference between resources and reserves. We've talked all afternoon about the various valuation standards, the commonalities. There are some differences, subtle differences, but for the most part, the commonalities are there in that we know that mineral resources are never mineral reserves, as they do not have demonstrated economic viability. In order to convert a resource to a reserve, it's required that at least at a minimum level that a pre-feasibility study be completed demonstrating positive economics for the deposit. We're all familiar with this chart. It shows up in the SME guide. It shows up in a similar fashion within NI 43-101, JORC, and so forth. And this very clearly depicts the progression of resources from exploration results up through inferred, indicated, and measured, how the indicated and measured can be converted over to probable and or proven. And the main thing that is missing from most of these appraisals is the consideration of the moderating factors or modifying factors at the bottom of that chart there, where you have to take into consideration the mining, the processing, the metallurgical, the economic, marketing, legal, environmental, infrastructure, social, and governmental factors. All these things go into play when converting a resource to a reserve. Now, a pre-feasibility study obviously requires a team of specialists: geologists, mining engineers, metallurgical engineers, marketing folks, legal, environmental, and a whole host of other disciplines may go into it depending upon the type of deposit that we're talking about. But what we do know is that it's a comprehensive analysis of a project's technical and economic viability. It's always going to be based on a preferred mining method and a preferred metallurgical process. And generally it's going to require the sign-off of a qualified or competent person, one or more. The completion of a pre-feasibility study is typically well beyond the capabilities and the expertise of the appraiser. More importantly, it's often, generally always, well beyond the scope and budget of the mineral appraisal. Now let's talk about a little bit what's the objective in an eminent domain action where the government comes in and does a taking of a mineral property from a private entity. The overall objective is to appraise the value of that taking such that it leaves the property owner no richer nor poorer as a result of the taking. Now, what happens when we get unrealistic and unsupportable low values? That's going to harm the condemnee or the property owner, and it's going to unjustly enrich the condemnor. The reverse of that, if we're going to get an unrealistic and unsupportable high value, it's going to harm the condemnor, the government entity, and it's going to unjustly enrich the condemnee, the property owner. That means from the outset that a realistic value determination is the mandate for the appraisal process on this type of an action. Sometime back, after seeing a number of deceptive type appraisal practices, I was listening to a forum, a technical forum, discussing resources reserves in conformance with those guidelines. And I posed the question, why do so many appraisers disregard the definitions of resources and reserves and so forth? And the answer was because we as appraisers enjoy latitude in determining how we apply those things into the appraisal. Well, latitude, again, going back to that definition, is freedom of action or choice, no bounds. But it seems to me that there should be the requirement that you stay between the lines on some of these things when we have these guidelines in place. More importantly, exercising an unrestrained degree of latitude in the appraisal process does not comport with the recognized appraisal objectives, which are standardization, consistency, transparency, objectivity, independence, and above all and beyond all is the reliability of the report at the end of the day. So I question, does latitude even exist? We have mining industry standards and guidelines that have been in place since the 1980s. We've got JORC since 1989 with its valuation component. We've got SME guide since 1992. We've had 43101 since about 2001. So in essence, we're looking at over 25 years that these things have been in place. And if we're practicing in this field, we should be acknowledging that they're there and they're there for a reason. The Appraisal Institute has a code of professional ethics and standards of professional practice. That's been generally guided by the principles put forth in USPAP since 1989, and the federal land acquisitions are yellow book since the early 70s. Those are the two guiding lights, I guess, if you will, for the appraisal practice in the mineral industry. But more importantly, appraisers that are working in this mineral appraisal sector also come from technical backgrounds that have their own codes of ethics. We have the IIMA, which we've discussed the codes of ethics here earlier today. We also have the National Society of Professional Engineers, state engineering licensing boards. Similar thing with American Institute of Professional Geologists, AIPG, and state licensing boards. Each one of these entities has a code of ethics that requires many of the same types of issues that are addressed within the SME guide and JORC and all of these other guidelines. The main thing is to consider is that all of these codes of ethics and standards and guidelines are designed to eliminate subjective interpretation. And to me, that means it's to eliminate or limit this latitude concept. So these standards have been in place, like I say, for over 25 years. So I question, should a credentialed mineral appraiser still be producing a report and working within the realm of proven and possible reserves, proven and inferred reserves? These are terms that I've encountered in appraisal reports. And if you're working within the guidelines, how do you explain in a court situation why this guy has 40 million tons of proven and possible reserves and you're only seeing 6 million tons of reserves? These are very disparate numbers that can come out with these types of classifications. How should we still be at this point in time seeing financial feasibility determinations being based on exploration data? How should we be seeing net operating income value determinations being based on historic and inferred resources? If there hasn't been a drill hole put down on that property in over 60 years, how can you take that data forward and develop a net operating income model on the basis of that? That's not latitude. That's primarily obfuscation and deception. Or another way to look at it is latitude just a veiled form of client advocacy? Or is it reflective of a combination of lack of competency, malpractice, ethical violations, or potentially rising to the level of fraud? That's a legal issue, and it's a hard concept to prove in court, obviously. But the definition from the dictionary is the intentional perversion of truth in order to introduce another or to induce another to part with something of value or to surrender a legal right. And I think that in context in those words is very simple to understand that some of these types of practices may start approaching that level. So you question whether or not in eminent domain appraisal should latitude, if there is any, include fraud and deception. And I found a quote by Agricola from 1556. It's complained that some sellers and buyers of shares and mines are fraudulent. I concede it. But can they deceive anyone except a stupid, careless man, unskilled in mining matters? Fairly profound for that time. Who's really being deceived by the latitude-based appraisal? It is those that are unskilled in mining matters, because they're wholly dependent upon appraiser's asserted level of competence, his purported reliability on the work product, and a presumed veracity in the appraiser's testimony in a court of law. So the condemnee and the condemnor are both going to be subject to this. But more importantly, it's the unskilled in mining matters, which are the hearing officers, the arbitrators, the judges, and the juries. And at the end of the day, when an exorbitant award is made, it's going to be the taxpayer that's paying the price on this. If it's a less than normal value, then it's going to be the property owner. But these folks are all innocent and they're unskilled, and that's why they're hiring mineral appraisers. The deceptive practice is generally carried out through style over substance. You can inflate and misrepresent your expertise and competence both in your written report as well as in courtroom testimony. I've seen it very often. You can misuse or wrongfully adapt the standards and guidelines, the SME or the 43101 type guidelines. So then, on that basis, you develop both invalid and unsupportable report findings, but they can be very impressive if you have that writing skill that was talked about earlier. You can produce inaccurate and unsupportable testimony just as easily in court. Again, you can be impressive in doing it, but does it start approaching perjury? These techniques can often be adeptly employed to take advantage of the unwitting and affected party who is unskilled in mining matters. The obvious indicator that I've seen, and I've seen it many times now, so when two value determinations differ by a degree of magnitude. If you get 6 appraisers out on a property and 5 of them can come up with a value that's ranging between 4 and 5 and 7 million, and then you have one come in at 40 million, where do you think that $40 million appraisal value is coming from? It strongly suggests that that appraiser may have completely missed the mark on highest and best use determination, or fabricated a determination of value based largely on speculation and conjecture. Unfortunately, the deceptive appraisal, or the value that's determined and accepted, harms not only the affected party, but it also affects the appraisal profession as a whole. What types of deception are being used? I'm seeing bogus mining methods put forward in an appraisal. I've seen where in a gypsum deposit, where there may be existing natural gas pipelines, when a new one comes in under a condemnation, I've seen the property owner's appraiser state that a 350-foot requirement that you can't blast within a 350-foot buffer of an existing pipeline is going to render this entire property non-mineable and therefore a total take. Yet, 10 miles down the road, mining that same gypsum deposit with a continuous surface mining machine, they are mining right up to within 15 or 25 feet of these pipelines. And obviously it's a recoverable deposit. So you see that type of thing. You see somebody come along and you take a wedge on a power line going across the top of a mountain at the back of somebody's aggregate deposit. It's going to take out a slice of material vertical and render it sterile. I've seen the appraiser come in and say that material would have been mined in year 1. Well, you had 19 years of mining that you had to do into that mountain before you ever got to it. So it would have occurred in year 20, not year 1. We're seeing disregarding or ignoring of statutes and guidelines, complete failure to account for diminution in value. And the last one, that my favorite, is what I call the proverbial cumulative effect house of cards approach. That's where you assemble invalid, non-supportable mine development assumptions, then use those as the basis for a also unsupportable NOI valuation when applied to resource stage property. How do you do this? Well, step 1, and these are actual situations that have been encountered in projects. Maybe you disregard a resource reserve analysis that has been completed by competent geologists and create your own. How do you do that? You establish a hypothetical pit limit by drawing a circle around every drill hole on that property, constrained only by patented claim boundaries. Then you disregard the fact that many of those drill holes contain little or no economic mineralization. You apply an average drill hole grade across the full pit limit and an arbitrary depth. Don't account for dilution in any manner whatsoever. And then take it a step further and claim that the packaged civil engineering cut and fill volume software actually is producing a geologic block model. Doesn't happen that way. It gives you cubic yards, period. Assert all resources are proven and probable reserves because the project has a permit. Environmental considerations is just one of the modifying factors that we looked at in the resources to reserves conversion. So having a permit does not convert something to a reserve. You can conduct no metallurgical recovery technical analysis. Instead, apply a 20% contingency factor to your operating cost to account for that. You disregard whether or not a saleable product can even be produced metallurgically. All these things are just looked aside. Then you assemble a production model based on all of that. You go to step 2, and having built that production model, you fine-tune it. You apply some of your economics 101 knowledge. You assert that a decrease in supply results in an increase in demand in a fixed demand market. Conclude that a threefold increase in supply will be absorbed in that fixed demand market. And assert that that increased demand is independent of probable product quality deficiencies. Determine the net operating income value on the basis of all of the above, and then conclude that the resultant NPV is the value of the in-place resource for a resource that at best could have only been classified as an inferred resource per SME guide or any other guidance document. Then get on the stand and testify that all of this is consistent with both SME guidelines and USPAP. That, folks, is latitude, or a lot of nerve. Where does this deceptive type of practice take us in a post-BRIEX world? Are we still going to have to admit and I've put question marks after Mark Twain's name there because I can't substantiate that this really came from him, but it's always attributed to him. A mine is but a hole in the ground with a liar at the top. We've got to have come further than that in this day and age. Given the existence of these standards and ethical obligations, there really is no room in the appraisal practice for self-proclaimed latitude in the practice of appraisal. There is, and justifiably so, plenty of room for professional judgment, and I saw that term on earlier slides today. I'd like to think that this professional judgment would be predicated on competence, transparency, ethical application, and full disclosure. Strict adherence to these standards and guidelines is what differentiates the ethical practitioner from the deceptive practitioner. So I took the liberty of excerpting the headers from the Codes of Ethics from the IIMA Revised Ethics. It just is now in the process of being developed. I had to cheat a little bit. This is past my date of submission of this report, but you'll see each one of those rules addresses these very same things. And I think that what we have to do now is start looking at the fact that the violations of these Codes of Ethics by members are going to be grounds for disciplinary action, and looking into the process of going through the complaint process and getting these things enforced. I see it on a monthly basis in professional engineering publications from every state that I'm registered in, where people are being literally enforced upon for significant violations. Everyone makes mistakes, but deceptive practice is completely different from that. So I'll leave that thought with you, and I thank you for your time.
Take to the mic and just assure you that since 2001, the IIMA has had a procedure specifically followed, and over the many years, we actually have disciplined members, and we have caused members to lose their membership because of what you put up there. Thanks very much.
Thank you. Any other questions?
Graham Davis, thank you very much for your talk. We all have seen these kinds of things, I'm sure. My question to you is how these kinds of things can be sustained. For example, I would presume that once somebody gets dauberted or the court, you point out, someone points out this is in violation of SimVal, SamVal, ValMin, SIM standards, the court would presumably agree, and then this person would be denounced, or the opinion would be denounced, and that may become public. Isn't there some kind of natural selection process where these, I don't know if it's unethical or incompetent or both, folks get bounced out of the business? Or is it your opinion that they stay in the game and can continue to do this time after time?
That's a very good question, and that's, I guess, probably the reason why I put together this paper. They do continue, I think, to bounce around out there. A lot of it in a litigation situation is going to be dependent upon your legal counsel and how they present the case. You as a technical expert can be right on track with exactly what needs to be done, and you may be standing on valid and solid ground. If your client's legal counsel chooses to go a different route than that, and you have somebody that can get up there and give a dog and pony show that is nothing more than smoke and mirrors and convince the jury that they're right, they will continue to thrive, and these awards will be continuing to come down the pike. I guess that's why I say I think it's, and I'm glad to hear, John, that enforcement has been an active part of the play, but like I say, when I get a newsletter from every state, I'm registered in 9 different states as a PE, and every one of them has 2.5 pages of enforcement violations, or violations and enforcement actions. And I ask myself, how do these people continue to practice? And I simply can't answer that, but I thought this was just an excellent opportunity to maybe make some of fellow practitioners aware of this type of thing, so that there is an awareness out there.
Trevor Ellis. I just want to add one more thing substantiating what you've said, but you've talked about financial implications. There's more than that out there. I recently worked as an expert defender for a person who was promoting mineral properties, trying to understand what would be the really valid way of doing things, but got tangled up in utilising some of this type of thing that you've been talking about. And he's now in prison for 8 years.
Okay, so there is.
But the experts he relied on, they're still out there.
Yeah. Yeah, it's amazing, and that's one concept of it that was touched on in earlier talks today, and that was if you don't have the expertise, go out and get it. Well, if you're going to go out and get it, get somebody who themselves is competent. Don't pull in somebody else that's equally as incompetent and then pass that off as a product.
I just want to make clear that these are people who do have registered, certified, qualified things after their name,
Right.
who did the work that he relied on.
Yeah. Very true.